Welcome to the first session of our four-part New Dentist Survival Guide series, Setting Yourself Up for Success. I'm Dr. Jerica Cook and the current chair of the NISTA New Dentist Committee. This is the third year we are offering this webinar series to new dentists across New York State, and we want to thank MLMIC for being our sponsors for this webinar series. MLMIC and New York State Dental Association have worked together since 1992 to provide dentists the best liability protection available at the lowest possible premiums consistent with fiscal responsibility. MLMIC policyholders from Buffalo to the Bronx enjoy localized risk management guidance, claims protection, and underwriting support, in addition to benefits and expertise not found anywhere else. And I will say that I myself do have a policy through MLMIC, and I have zero complaints. They have been great for a new dentist. So a little housekeeping. At the end of the program tonight, you must respond to 3 questions in order to receive your CE credits. Also, we will hold questions until the end, and please submit your questions to the Q&A section, not the chat. Now, I would like to introduce Tammy Smelts from MLMIC, offering medical malpractice insurance in New York.
Good evening, everyone. My name is Tammy Smelts, and I'm the Content Marketing Manager for MLMIC Insurance Company. On behalf of MLMIC and NISTA, we welcome you to Session 1 of NISTA's 2023 New Dentist Survival Guide Series, Welcome to the Jungle. I would like to take a moment to thank NISTA for this opportunity to provide one of our educational programs as part of their Dentist Survival Guide series. As you may already know, MLMIC is New York's #1 dental professional liability insurance carrier. For over 40 years, we have built relationships and provided affordable coverage to dentists across the state. Every MLMIC policy includes New York-specific risk management services, a 24/7 hotline for emergencies, and pure consent to settle. Follow us on LinkedIn and Twitter for up-to-date risk management tips and industry news. The presenter this evening is Al Anthony Mercado. Al is the managing attorney for Mercado May Skinner, an in-house law firm for MLMIC Insurance Company. Mr. Mercado is also an employee of MLMIC Insurance Company. And with that, I turn it over to Al.
Thank you, Tammy. And thank you again. It's my pleasure to be here to be presenting on this very relevant and important topic. This presentation, Welcome to the Jungle. It literally is a jungle out there. And a jungle in terms of litigation. New York State is one of the most litigious states for malpractice in the entire country. So a little bit of housekeeping on my part. Disclaimer: what presentation would be good without a presentation, without a disclaimer from a lawyer, right? So essentially, I am giving you general legal advice in this presentation. This is not meant to constitute specific legal advice to any specific legal question or situation that you have. I encourage you to reach out to an attorney that you retain to get that type of advice with regard to a malpractice case. And finally, the statements, views, and opinions expressed in this presentation are solely my opinions and statements. So what are our objectives tonight? Well, first of all, we want to talk about the occurrence and claims made insurance policies. We're going to talk about the key differences so you can have a basic understanding of what an occurrence policy is and what a claims made policy is, as well as a tail coverage. We're going to identify some common claims seen in dentistry. And then we're going to talk about understand what leads to these type of malpractice claims. Finally, we're going to discuss risk management strategies to help avoid these type of claims. So backward engineering here. Let's talk first about insurance. Why talk about insurance? Well, insurance means protection in case of a malpractice case. You don't want to be in a malpractice case and not have a malpractice policy. And when I first began my career, for instance, some of the settlements and the verdicts were probably in the $75,000 to $100,000 range. Today, those dental malpractice cases can lead to multi-million-dollar settlements and multi-million-dollar verdicts. So having insurance it's extremely, extremely important. So what should you look for in choosing a malpractice carrier? Well, first of all, is the claims experience. You want to see, are they in the particular place where you're practicing? For instance, if you're practicing in New York, you would want to have be insured with a carrier that has a background in New York, who's been in New York, who's handled claims in New York. Financial strength, AM best rating, A+ or better. That's a good indication of financial strength and stability. And as you may be aware, AM Best is a award-winning industry agency which rates insurance companies based upon financial strength. Finally, the choice of insurance policies and discount programs. Does the particular insurance company have such programs so you can actually get a discount? Does the malpractice carrier offer risk management support and education, such as programs like this? And finally, are they invested in helping the dental community? For instance, MLMIC Insurance Company was partnered with many others in the defense bar, as well as other partners, in defeating the recent legislation from the trial lawyers, the Grieving Families Act, which would have raised insurance rates for providers in the state up to 40%. So you want to see if the carrier is invested in the dental community, providing services and educational programs such as this. Now, basically, there are two types of policies, as I said before. There's an occurrence policy and a claims-made policy. Understanding the difference between the policies is extremely important for malpractice coverage, but it's also important for employment. As a sidestep here, you will be reviewing, or you may have reviewed, an employment contract. An employment contract will offer you one of the two policies. They'll offer you an occurrence policy or a claims-made policy. Knowing the difference will help you negotiate an employment contract as well. But in terms of malpractice, knowing the difference is very important, especially with regard to tail coverage, which I will explain in a moment. Now, the two types of policy, the occurrence policy and the claims-made policy, they're essentially the same type when they are in continual force, and they give you the same type of coverage. The principal difference of these two policies lie in their pricing structure and the protection they provide after they are canceled or non-renewed. And I'll explain that difference in just a few minutes. Now, both types of coverage have primary limits available in the amounts of $2 million and $6 million per person and annual aggregate, which means the entire year of the policy for dentists. So let's first talk about the occurrence policy. The occurrence policy is a policy protects the policyholder for the alleged acts of malpractice that occur while the policy is in force, no matter when the claim is reported. To give you an example, if you're employed with a dental group for 1 year and you have an occurrence policy, you have a alleged malpractice claim that comes in for that period, you leave that employment. So with an occurrence policy, even though you left, that policy was forced in effect for that time you were practicing there. So it doesn't matter when it was reported, even if it was after you left, you would have coverage with an occurrence policy. With an occurrence policy, you also don't have to buy a tail coverage. So tail coverage is actually a separate type of policy that you must, well, not must, but you should purchase if you have a claims-made policy after you cancel or it's non-renewed. An occurrence policy is generally more expensive than a claims-made policy at the very, very beginning. So now let's talk about a claims-made policy. So the claims-made policy, less expensive at the beginning, and the claims-made policy protects you for the acts of malpractice the same, but they both must occur and be reported during that policy period. Going back to that employment situation for 1 year with the group, and then when you leave, so you have a claim of malpractice that comes in during that employment period. Now, if you did not buy a tail and it comes in after you left, and that policy was canceled or non-renewed, you would have a gap in coverage and no coverage with the claims-made policy. You would have to buy a tail, or it would have had to be within 60 days following the cancellation or the non-renewal of that policy. So again, the claims-made policy, the malpractice both must occur and be reported during the policy period. So if you change employers and you don't get a tail, you can run into a problem with the claims-made policy. So now we're going to talk, we talked about the protection part of it. That's the insurance part of it. The occurrence policy, the claims-made policy. Why would you need insurance? Because some of the common claims that we see against dentists. And I'm going to be talking about these common claims, then drilling down in a root cause analysis type of analysis and go over then some risk management strategies to avoid those type of claims. So let's first talk about lost payments. Lost payments can take two forms. Lost payment can be a settlement of a malpractice case, or it could be a verdict. And a verdict, as you may be aware, occurs after a case goes to court, it goes to a jury, and they render a verdict, and then they decide on the damages. What are the leading causes in types of claims against dentists? Well, first is root canal treatment, and that would include the broken files, tooth perforations, root canal being done on the wrong tooth, failed or incomplete root canals, swallowed files, or paresthesia. Another type of malpractice claim or common claim involves implants. And the type, what we see there is osteomyelitis status post-implant, failed implants, graft failure, fistula development, paresthesia. Finally, tooth extraction. That would be the wrong tooth or teeth being extracted, fractured jaw as a result of an extraction, retained root teeth tips, paresthesia. Now, you can see that in each one of these, there's paresthesia. Paresthesia is a claim. Obviously, we know what that is. And what the plaintiff's lawyer, that's representing the patient in the case that's bringing the malpractice case, they like to look for paresthesia or those type of things in their cases, like to bring them in their cases, because that brings up the amount of damages that they can get. So no dentist is immune from liability. No specialty is immune from liability. If you're a general dentist, you can face malpractice liability. If you're an endodontist, you can face liability. Oral surgeons, orthodontists, pediatric dentists, periodontists, prosthodontists as well can all face malpractice liability. Now let's take a quick look at the type of cases and type of claims that we've seen be brought against them. And again, with endodontists, we see the failed root canals, the drill bits with alleged infections, paresthesia caused by nerve injections, roots that have been overfilled or perforated. Oral surgeons, the type of claims we see complications from extractions and the placement of implants. Orthodontists and pediatric dentists, the type of claims that we see involve the failure to diagnose the slow loss of baby teeth, the crowding of baby or adult teeth, the overuse of appliances, or the underuse of appliances, it could be, the failure to accommodate proper spacing of teeth. Periodontists, common claims here, the failure to diagnose and treat gum disease, improperly measured pocket depths, and undiagnosed infections. Prosthodontists, we see the improper placement of veneers, crowns, and bridges. Now, understand that in a court of law, a dentist who undertakes work of a specialty nature will be held to that standard of care of that specialty. So that if you are a general dentist who's doing root canals, you will be held to the standard of an endodontist, et cetera. And you can see the point that I'm making. So in how this would play out in a malpractice lawsuit would be the case, there would be an expert who would review your care, and that would be for the plaintiff. They would see if you met the standard of care or not. If they feel you did not, then a case could be brought. That then you would have a deposition, or there would be depositions, what's called discovery, exchange of medical information, the dental record, for instance. And then ultimately you would work your way up into having the trial. Now, at the trial, there would be an expert testifying for you and an expert testifying for the plaintiff. The expert testifying for the plaintiff will be likely in the specialty of the work that you performed. So when it goes to the jury, you will be held to the standard of that specialty. Now, a dentist can also face claims for the failed to diagnose oral cancer. And this is nothing new, but because of Lavernes Law, which came into effect in 2018, that really makes it more pertinent in malpractice cases. What Lavernes Law essentially does, it extends the statute of limitations. The statute of limitations essentially is the time to sue for malpractice. Generally speaking, for adult patients, that is 2.5 years. And for pediatric patients, it could be up to 10 years, a sliding scale. So, or the age of 2.5 years after the age of 18. So that would be 21. So the longest you could be for pediatric patients is age 21, but it could be up to 10 years if they're not in that age group. Now, what Lavernes Law does in the failure to diagnose cancer is that it becomes known or should have known of the misdiagnosis or up to 7 years. So it can significantly extend the time to sue for malpractice if it's based upon the failure to diagnose a cancer. All dentists can face claims for breach of contract or for refund or for incomplete or refund for incomplete or unsatisfactory work, as well as intentional conduct. So that would be sexual harassment or assault. Now, normally we do not see intentional harm, which would be sexual harassment or assault brought against dentists. That is an extreme minority of type of cases. However, that would be a 1-year statute of limitations. Now, what's different about breach of contract, and this is a difference between dentistry and medicine, is that in medicine, you very, very rarely will see a breach of contract claim. It's rare, but not as rare in a dental malpractice case. So they could bring a case of malpractice and breach of contract. Now, breach of contract would be basically you did not achieve a certain result that was expected. So it gets into expectations. So if you're talking about cosmetic dentistry, that could give rise to a breach of contract claim. And I'll talk about more about how we defend that and how to prevent that type of claim. Why do you want to prevent that type of claim? Because it's the 6-year statute of limitations, and it gives rise to economic damages separate and aside from the malpractice allegations. So we're drilling down further. So what are the most common allegations rather than we're seeing against dentists? Well, 58% were related to the performance of a procedure. 17% were related to the management of treatment. 7% were related to a foreign body. 7% were related to misdiagnosis or failure to diagnose. 11% were related to a combination of the factors. So the performance of a procedure, that would be, to give you an example, the difference between the performance of procedure and management of treatment. You could have, say, a root canal that was performed. That's the performance of the treatment or the procedure. Now, what the sequela of that, or what happens after that, it could be an infection, it could be a paresthesia. That's the management of a treatment to distinguish. Now, you would see that 7% were related to misdiagnosis. That gets us to the failure to diagnose cancer, for instance. So keep in mind that 7%, although it only looks like a small percentage, when we start talking about damages and value of cases, that 7% can actually be an extremely high amount in terms of damages. So what are the most frequent procedures leading to malpractice claims that we've seen? Well, 19% are root canals, 18% crown or final restorations, 17% extractions, 16% bridges, dentures, and removable appliances, 13% implants. This is consistent. These are statistics that come from MLMIC insurance companies' work, analytic work, as well as MedPro, and they've partnered with regard to this. And I can tell you from my experience defending these cases, these are accurate. A lot of the cases that I've seen, many of the cases I see, I should say, statistically, root canal type cases, malpractice cases, the crowns, the final restorations failing, and extractions leading to different types of damages, including paresthesia. So the most frequent type of diagnostic related claims that we see, oral cancer being the first, periodontist being the second, infection and caries being the fourth. The most frequently alleged injuries, tooth damage being the first one, nerve damage being the second, infection, pain, and death. So tooth damage makes sense. I mean, it's reasonable to feel that that's going to be the first one. Nerve damage, again, this is something that can lead to a higher type of award or settlement in a malpractice case. Infection, patient becomes septic. That can also lead to a high value. Pain and suffering makes up the largest component of a malpractice settlement or a verdict. That's the biggest part of the award. Death, Death, obviously, if there's economic damages, if you have a high earning a patient or a patient who has a family under New York State wrongful death law, even as it's written now, could lead to great economic damages in a malpractice case. Now, anesthesia-related injuries like respiratory arrest, hypoxic brain injury, and death, these are infrequent, but when we have them in malpractice cases, the awards, this is where we're getting into the multi-million-dollar type of awards. Going back to the first part of my presentation about protection, you want to make sure you have protection with a good malpractice policy. You don't want to find out that you have that your malpractice carrier is in trouble when you're facing a multi-million-dollar claim. So now let's drill down into the common claims and the causes of the common claims. And you see over here, we have technical skill, we have behavior-related, clinical judgment. So let's start again first with technical skill. This essentially is your competency in the procedure itself and treatment. A lack of training or experience, particular procedure or treatment, showing that a poor technique had been used, incorrect treatment, or retained foreign bodies. Now, as a sidestep here, having represented dentists for over 30 years in malpractice cases, I can tell you that the first part of the deposition, you heard me use that term before, a deposition simply is questioning. You're being questioned. It's like an interrogation by the patient plaintiff's attorney. And the first thing they'll ask you about is about your background. They'll ask you about your competency, questions that go to competency. They'll go to your training. Where did you train in a particular procedure? How many of these have you done? Have you had any problems with them? And I'm making this overgeneralizing, but essentially that's where they set you up in the malpractice case, generally speaking, because they already know what their case is about. So again, the technical skill is a leading cause of the common claims that we're seeing in the allegations. The second one, behavior related, this goes with expectations. Now, as you all probably were on this call, or you will be, is that in dentistry, expectations can run very high. So you can have a patient who is expecting the case to come out like this, come out absolutely perfect, and you strive to do that. That's the common goal you have with the patient. But you have to be very, very careful to make those expectations reasonable. If the patient does not have reasonable expectations, they will never be happy with the case. And that basically is leaves a fertile ground for discontent to grow and for a malpractice claim to take root. So dissatisfaction. If a patient is dissatisfied, that's another leading cause of a claim. Address that dissatisfaction. I'll be talking about that in a little while with regard to the risk management strategies to avoid these claims. Compliance. Is there non-compliance or are they not following your direction? Are they refusing referrals? Not following up with appointments? This gives you an opportunity for patient education. But where you don't have compliance, the case is going to suffer. Where they're not following up with appointments, the case is going to suffer. That's going to lead to, that's going to affect the ultimate outcome of the case and their satisfaction. Finally, clinical judgment. Clinical judgment, this is the leading cause here is an inadequate assessment of the patient prior to treatment. Is this basically the right treatment for this patient and their condition? Is it an appropriate treatment or not? Is it based on the patient history? Is the total patient being taken into account? Is there a failure to seek consults as well as selecting the most appropriate treatment or treatment plan or modalities for this patient? Now, what we lawyers do is we use the retrospectoscope to look at all of this. Now, since we know that this is a common this is a leading cause to common claims of dental malpractice, be aware that your clinical judgment, how it will be viewed later on by other people other practitioners or providers who are treating the patient, but also how lawyers and others, experts, would be looking at it later on in a case. Drilling down further, we have two more. So where we have lack of communication or poor communication and poor documentation. Now, communication and documentation, you'll hear me say it again and again and again, is the most important thing to protect you, besides insurance, from a malpractice case. So what we see is where there's poor or inadequate verbal and written communication, things like consent, treatment plans, expectations, dissatisfaction, changes in the plan, follow-up, are there questions that are outstanding and not been answered? These all lead to allegations and common claims. Documentation the same. One of the things that is a famous and commonly used plaintiff's attorney saying is, if you didn't write it, it didn't happen. And I hear it a lot. So that if there's something that happens in the case, is part of the treatment, if we see insufficient documentation of treatment, about informed consent, the plaintiff's attorney, they have an easier job, because they say, if you didn't write it, you didn't document it, it didn't happen. It becomes a he said, she said type of situation, which is a very difficult thing to address in a malpractice case from the defense side. So now, how do we stay out of the courtroom? This is essentially where we're getting to the ways of the strategies to avoid these type of common claims. So we've spoken about insurance. We've spoken about the common claims, the procedures, the treatments. We've talked about the common injuries. We've talked about the causes of these, the technical skill, the clinical judgment, the behavior related, the poor communication, the poor documentation. So we already know what these problems are. How now do we address them to avoid these claims? And first and foremost, communication, documentation, informed consent. What I like to talk about in terms of avoiding claims for malpractice are these three, but I would add a fourth. I would actually call it the risk managed trifecta, where I would always say communication, documentation, follow-up. Now, informed consent to me is part of communication and documentation. So think in terms of communication, documentation, and follow-up. And then informed consent being a major component of that. Informed consent is almost always alleged in a dental malpractice case. The patient will say they did not fully understand what the treatment was. If they had known the material risks, benefits, and alternatives, they wouldn't have chosen that particular treatment. So again, your communication and your documentation with regard to informed consent, extremely important. We'll start with documentation. So with documentation, good documentation, there's no substitute for it. Good documentation is probably the single best way to avoid a malpractice claim. So that, like I said before, the plaintiff's attorney will say, if you didn't document it, it didn't happen. If it is documented, is a better way for me as your defense lawyer, along with you, my client, we can formulate a defense to the case. So nowadays we have electronic dental records, in addition to still the paper records, I'm sure. But and I'll be talking about some of the strategies with regard to electronic dental records and documentation, some of the pitfalls that we see in those type of records as well. So what should be documented? Well, what should be documented clearly are the services that are provided. That would include the date, the time, the initial entry, and on an electronic dental record, this should all be there. If there are instructions that are given to the patient, those should be documented, as well as if the patient's on any medications, do they have any reactions to any particular types of medications, and what prescriptions they're on. Patient compliance and patient input related issues. So if we have a patient who's non-compliant, who's missing appointments, this is something that I believe you should ask a little bit further than just saying instead of just documenting non-compliance or missed appointment. There should be a policy and procedure for missed appointments in your office. You should be aware of what that is, and that should be followed, so that if the patient doesn't follow up and the case suffers, and then they bring a malpractice case, then you will have it documented that you followed, or you'd have documentation of attempts to reach the patient to get compliance, but you will also be able to show that you in fact had followed the policy and procedure that was in effect in your particular office. Now, with regard to patient compliance issues, like I said just a few moments ago, just to write down that the patient is non-compliant is not enough. I like to suggest and recommend ask the patient why. Try to find out the why. There might be a reason for why the patient is not being compliant. There could be a loss of a job and a loss of dental benefits or a loss of income that is putting a financial strain on the patient's family, and therefore they're missing appointments because of that. So you want to find that out. If you find that type of information out, you're going to be in a better place to address it. All of what I'm talking about now, I want you to understand, I'm talking in terms of malpractice, but there is actually a nexus between risk management to avoid malpractice claims and good patient care. So really, we do this really for good patient care, but also to avoid malpractice, and that's a win-win situation for you. Now, if patients have complaints during the treatment, after the treatment, pay attention to those, document what they are. When you document what a patient tells you, you should be putting them in quotation. Patient states, this way there will be no question later on when I look at it or another provider or an expert looks at it, that that is in fact what the patient said, as opposed to you just paraphrasing it. So you want to document those patient comments, those patient complaints, and then show in the documentation that you in fact address them or try to address those type of comments or those complaints. That gives, again, ammunition to us, myself, and the client to formulate a defense later on. So communications can take various forms, but you want to document these communications. Now, these would be things such as the referrals that you make, and if the referrals are not followed or are refused. So again, just like with the non-compliance, what you want to do, you want to try to get to the root of why the referral was not followed or refused. There actually might be a reason why the patient did not follow up on the referral or is refusing it. And that gives you the ability to address it and then document how you addressed it in the chart. Telephone conversations, those should be documented. Emails that are treatment related become part of the dental record. Texts, and this is kind of a touchy situation because I realize that there's texting going on with patients and as well as physicians and other dental providers. Those actually, if it's treatment related, that becomes part of the chart. And I've actually seen, just to take a sidestep here, in a malpractice case, if there's texting on a phone, first of all, the device should be HIPAA compliant. If it's not, you're asking for trouble because you can wind up with a HIPAA claim as well, in addition to a malpractice claim, and you don't want that. But what the plaintiff's attorneys will do, their client has texts, and they know that you have texts on your end as a treating provider. They will make a demand for they can make a demand for the inspection of the device. So you want to stay away from that, as far as I'm concerned. If you're going to communicate, make sure it's done in a HIPAA compliant form and in a professional form as well. Texting, let's face it, even if it's HIPAA compliant, texting is not formal. We have tendency to be very informal with regard to texting. So keep that in mind. There might be abbreviations, there might be things that are just said in addition to treatment. If the patient feels that they have if they have a friendly relationship with you as well. So keep that in mind. So now let's move to talking about the treatment plan. So the treatment plan basically outlines what you're going to be doing with the patient. The patient should be given that treatment plan, and that should include the diagnosis and what's going to be done. That needs to be fully explained and understood by the patient. Now, I'm going to get a little bit ahead of myself here, but for good reason. So If a patient is to fully understand something, they have to be able to understand it. And so if English is not their native language, then there's a good chance that they may not understand it completely. So you want to elicit the help of a translator. That translator cannot be a family member. Cannot. So you have to get a translator to assist in that regard. Now, if there are changes in the treatment plan along the way, those should be communicated, discussed with the patient. Those should be documented that if there's a change, why the change, and the discussion took place. Anything that the patient says as far as comments, complaints, etc., in quotations, document that in the electronic dental chart record as well. So you want to document also the patient's prior dental and medical history. So the prior dental history is important because it gives you that baseline of what's coming in and what the patient had done before. If you can, try to get those prior records. If the patient can get them or you can get them, it'll give you more information about the prior dental treatment. Prior medical history or medical history in general can be very important. So I spent probably about 5 years working on the bisphosphonate cases with osteonecrosis of the jaw. And I was representing dentists in those cases. And I can tell you the majority of my clients didn't even have the physician's name in the chart. There was no communication with the physician. They didn't know anything about the medical history of the patient. And that led to some issues with regard to those, to my clients. So getting that history, is the medical history, in addition to the dental history, extremely important. Document a patient's complaints about prior dental work. Again, if they're making complaints, patient states in quotations, could be red flags. So the way I like to look at it, and there's really no statistical or analytical way of a basis for saying this, but from my experience, if you have a patient who's complaining about 2, 3, 4 prior dental providers, it should be a real red flag to you. And usually it will be they can't meet their expectations, something went wrong. Whatever it is, if there's complaints about several dental providers over a period of time, or they keep changing, it's something to really focus in on, to understand what you're getting into with that particular patient and that particular treatment plan. The one thing you want to do is never alter the records. Now, what does altering the records really mean? Altering the records runs the gamut of, you could just rewrite them, right? That you don't do that. You don't alter, that's altering. You don't do anything that's altering. You could rewrite them. You could change just one word. You could change any change in it that's not by addendum. It can be deemed an alteration of the records. Why is that so serious? That's serious because, first of all, it's a professional misconduct in New York State and most states, which is different than malpractice. Professional misconduct goes against those charges go against your license. So you can have your license suspended, revoked. You can have a fine. It's bad. You don't want to have that. You can, it's also a criminal act in New York State to alter a dental or a medical record. So be aware of that. Finally, in a malpractice case, if you alter the record and it's determined you alter the record, that will be an automatic finding of negligence or liability. So in malpractice cases in New York State, you have 2 phases. You have the liability phase and you have the damages phase. So when liability has to be proven before they move to the damages phase. So if you alter the record, you lose the liability automatically. They just go straight to the damages. So we don't want that. We don't want that to happen, in addition to it being potentially professional misconduct and a criminal act as well. So as I said before, changes should be made by addendum. So you should all be aware of how to make an addendum, but basically what you want to do in an addendum is you just basically write the word addendum, you put the time, the reason why you're making, and then the new information. You want to keep your documentation objective. If you're having problems with the patient, you do not want to air those problems in the dental record. So if the patient, I mean, don't get me wrong, if the patient is using profanity in the office, upset, you're not meeting their expectations, getting quotations, but you do not want to do anything like that. You don't want your staff, if they have the ability to put anything in the record, make sure it is objective. If it's not objective, it could look very, very bad in a malpractice case against you. So now let's move to informed consent, because informed consent is extremely, extremely important. Informed consent legally is the conversation between a dentist and a patient. So you see the dentist patient, that's who the conversation is between. Prior to treatment, where the options and material risks of proposed treatment are explained and discussed. So that's essentially what the legal definition is. If this was a malpractice case and there was a jury charge, this essentially would be the jury charge to the jury. So again, we're talking about options, material risks of the proposed treatment, and those would be material risks, benefits, alternatives, including no treatment. And if the alternative and the no treatment part of it, explain to the patient, if you do not go forward with the treatment the way I'm explaining it to you, this is what's going to happen. And as I've been alluding, or as I've said before several times, this needs to be communicated and then documented in the dental record. So who can give consent? Well, parents and guardians of children under the age of 18 years old can give consent. Anyone over the age of 18 and older can give consent. Patients who are under the age of 18, but who are married or have children can give consent. That's what legally is called an emancipated minor. So, we have situations, I know in real life, this is a very basic view of it. You might have a situation where patient is coming, a patient who is 16 or 17 years old, coming to the office and seeking treatment with a note from the parent. The suggestion or recommendation is to contact that patient's parent or legal guardian. So you can get the consent properly pursuant to the policy and procedure of wherever you're practicing, but clearly documenting it. And if getting it in written form, obviously, is the best way to do that. And then documenting it. Because as I've said several times already, if it's not documented, it didn't happen. So what must be explained in the informed consent discussion? Obviously, the procedure has to be explained in understandable terms. Understandable terms goes not only to language, but also goes to the educational level of understanding of the patient. So obviously, you're going to be judging whether or not, looking at the patient and getting a gauge of whether or not they're understanding, comprehending the procedure that you're talking about. So that's a first thing. Reasons for the procedure. Why are you proposing this particular procedure? That should be understood as well by the patient. What are the benefits of the procedure? So that should be some benefits of the procedure, as opposed to some other procedures that might be available. In a malpractice case, you'll have to explain that ad nauseum in a deposition and then potentially a trial. So again, thinking about it ahead of time in your career, knowing that you may change the way you're explaining the procedure to a patient in getting informed consent. One of the things that my clients have always told me over the years is that the way they practice, particularly communication, documentation, changed after they went through their first lawsuit. And unfortunately, and I in my view right now, I can't see everybody in the grid, but if you take a look at the people, if you could see the people in the grid, look to the left and right of you. Unfortunately, there's a very good possibility if you practice in New York State, the person on the left, right, up, down from you, they're going to be a defendant in a dental malpractice case, unfortunately. New York is an extremely litigious state. So moving on, the alternatives and consequences for the alternatives, including no treatment. I've talked a little bit about that already. What are the material risks associated with this treatment? and then give the patient an opportunity to ask questions and give answers. Again, documenting what the patient's asking, using quotations, and then whatever your response is to those questions. So again, going back to the understandability, I just want to make the point again. Make sure not only it's language, if English is not their native language or their first language, that's going to be an issue in a case. So make sure you get a translator and it's understandable. I realize that most of the written forms that exist either in electronic dental record or the pre-printed forms are in English. The translator is available, should be available to go over that with the patient for their signature and to give their consent as well. Also, something else I want to mention is that if someone else is in the room during the consent, document who else is in the room when you do the consent. This way, later on, it can corroborate. It could be also be someone who's working in your office. Document if they're there, who else was in the room on your end. If the patient brought somebody with them and it was appropriate and they gave their consent for the person to be there, document that in the chart as well. This way, later on, you'll know who it is. Understanding again that the statute of limitations or the time to bring a case, generally speaking for adults, is 2.5 years. So the lawsuit would not come a week, a month, maybe even a year after the treatment. It might be 2.5 years after the treatment, or in a pediatric case, up to 10 years after. So the good documentation is going to be your best defense in these type of allegations against you. So I've been saying it must be documented, the chart, informed consent, who's present, I've already mentioned that, and emphasizing again that the consent, the pre-printed form or whatever in the electronic dental record is not the consent. That is the legal document that shows a consent discussion happened. That's for me, and that's for whatever facility or office that you're practicing for. That is to be compliant with New York State regulation and law. Okay, but that in and of itself, the signature on there, without going over the other stuff, even if they say they've read it, even if they've initialed it, if you haven't gone over it with you, it's not going to, we're going to have a difficult time in defending that. That's not real consent. So what are some of our key takeaways here tonight? Some of the key takeaways here is understand what the most common causes against the dentist and the best way to avoid such claims. So again, we've talked about the type of causes, the type of claims that we've seen in allegations. We've talked about, we've drilled down into what causes those. Those would be the technical, behavior related, as well as the clinical judgment, poor communication, poor documentation, those being the leading causes of malpractice cases. And as I said earlier, if you ever are in the unfortunate position of being in a malpractice case, the first questions that you will be asked in that case will be about your background and what your expertise or what your training is in that particular procedure. They will put the informed consent form in front of you, and they will ask you, did you go over this with the patient, with my client? Did you go over this? If you didn't, and again, if you didn't document it, it didn't happen. So that is a common theme of what plaintiff's attorneys use and why you want to document. Risk management trifecta: document, communication, documentation, follow-up, and then informed consent fitting under the documentation and the communication. Understand the type of coverages that are available. So again, we have the occurrence policy. This is the type of policy where you do not have to buy tail coverage. It is more expensive, but it's not as tricky. There's not that mechanism. So when you have that occurrence policy, even though you may have left that employment and there's a claim there and that policy is canceled, you'll still have coverage. Whereas with the claims made policy, as I explained before, it's less expensive, but you will need that tail coverage. And the tricky part about it is with regard to when that claim comes in. That claim must occur and be reported in the policy period. So again, going back to my example earlier, that if you have that 1 year of employment, you leave, there's no tail coverage that's purchased. And that then the claim comes in for that time period. There's a good possibility that you're not going to have coverage. And as a quick sidestep, again, I made one earlier in the presentation to employment, knowing whether you're getting an occurrence policy or claims made policy. What you want to do is you want to see in that employment contract, if you have a claims made policy, who's buying that policy. So if there are any questions, I'll be happy to take them now. And I want to thank you for your attention tonight. Thanks.